Thank you. Good evening, everybody. I'm Frances Cook. I'm the Chief Executive of the Howard League for Penal Reform, and I'm very pleased to welcome you all here today. I have, of course, some housekeeping, which I'm going to do first of all. Please will you turn off your 3G and 4G on your phones, because apparently it interferes with electronic stuff. But you can go onto the free Wi-Fi, which is open access. So if you log onto that, you can get Wi-Fi. And I've managed it, and if I can do it, so can you. A cryptic message for those of you who have a little slip of paper. It's not 8:15 anymore, it's 8 p.m. Those who have the piece of paper will know what that means. I have to thank Clifford Chance for giving us this fantastic facility. The firm's been a fantastic support to the Howard League. They give us trainee lawyers to support our legal work, and it's very much appreciated. This is a wonderful resource as well. So I'm very pleased to welcome you to our annual lecture in memory of Milo Cripps, Lord Parmoor, who was a long time and generous supporter of our work. I knew him for 20 years. And as you know, the Howard League is a charity that relies on voluntary donations, and we're very grateful to Milo Cripps for giving us a very generous donation. And we are one of the very few charities that does not accept government funding. So if you are not already a regular donor, I ask you to give us the equivalent of a cup of coffee and a croissant every month. Not much to ask, but it just keeps us going and keeps that independence going. And the Howard League has been going since 1866, which of course was, you all know, the first Royal Commission on capital punishment that eventually led to public executions being abolished. And it was a turning point, because it was when punishments moved from being a public display to behind closed doors. And you'll know that public displays of punishment, of course, obviously, generated more disorder, more violence, more drunkenness. And particularly if you read accounts of executions, you'll know that there was a lot of increased violence. So the big question we asked when we were set up in 1866 was, what do we do with people who transgress? And we've been asking the same question ever since. On a personal note, I, for 5 years, worked at Amnesty International before I came to the Howard League. And I was the death penalty coordinator there. I was very involved in the parliamentary debates in the 80s. Some of you will remember that. When there were lots of votes to try and reintroduce capital punishment for all sorts of different things, but there was no consensus. And I believe that consensus has actually, the lack of consensus on reintroduction has strengthened. There is no call to reintroduce into this country. So the Howard League was always part of that struggle over 150 years to abolish capital punishment. And we took immediate action recently when it became clear that the government had failed to uphold the long-standing principle and commitment that in any extrajudicial support, the government would seek assurances that the death penalty would not be sought or carried out. We wrote to the Prime Minister, we hosted a meeting of the key organisations involved, and I'm delighted, therefore, that Ben Emmerson, the preeminent legal mind on the issue, is here to speak today. Ben was a founder member of Matrix Chambers and has taken cases and has experienced litigating before international courts, all of them. And if you look him up, his CV is, this long. And helped draft the 1998 Human Rights Act, which is one of the most important pieces of legislation in the last 30 years. Probably the most important piece of legislation in the last 30 years. He's worked on gay rights, freedom of speech, human rights, and in some of the most challenging cases. I am honoured to introduce Ben Emmerson, QC, to speak to you today. Ben.
Thank you all for making the trek out to Canary Wharf. And may I begin by extending my thanks to the Howard League for Penal Reform and to the organisation's indefatigable Chief Executive, Frances Crook, for inviting me to deliver the annual lecture in honour of Milo Cripps, Lord Parmoor, a supporter of penal reform and a major benefactor to this day of the organisation's valuable work. My topic this evening is the British government's recent actions in undermining the United Kingdom's principled opposition to the death penalty. I'm prompted to speak and to give this lecture immediately by the actions of the Home Secretary in the case of Alexander Coty and El Shafee El Sheikh, two British men currently being held by Kurdish forces in northern Syria. As you will all know, this summer, the Home Secretary, Sajid Javid, took the unprecedented step of agreeing to provide potentially decisive evidence against these two men to the United States authorities in order to assist a federal prosecution in which, on conviction, they will face the death penalty and be executed. But the implications of the Home Secretary's decision travel much further even than the fate of those two individuals. As his own officials predicted in written advice to the Home Secretary, his actions have been immediately and utterly corrosive of the United Kingdom's hitherto well-deserved international reputation as a global leader in human rights protection, a country dedicated, in other words, to what is nowadays called the rules-based international order. My task this evening is to explore how and why this was allowed to happen, and to make some suggestions for what can be done to put the situation right. I embark on both limbs of that task with caution, because the story is not yet over. The mother of Mr. El Sheikh has applied for permission to bring a judicial review of the Home Secretary's decision, albeit retrospectively. The application was argued before the Lord Chief Justice, Lord Burnett, last week, and judgment has been reserved. We must, therefore, temper our condemnation of these unprecedented and unprincipled actions of our current Home Secretary, at least to some extent, until we see whether what went so badly wrong in this case is now to be put right by the judges. But that should not stop us from exploring the implications, some of them, I'm afraid, sadly, already irreversible. And it is entirely appropriate that the Howard League's annual Parmoor lecture should be the occasion on which to carry out that exploration. As Francis has said, at its very inception in 1866, the Howard Association, as it was then called, began the first serious campaign for penal reform with a commitment to the abolition of the death penalty. It was consistently at the forefront of the abolitionist movement and was credited by Roger Hood in his compendium on capital punishment with having made a major contribution to the progressive abolition of the death penalty, and not just in this country, but by example and by extension worldwide. When news of Sajid Javid's unilateral decision to roll back this country's commitment to that great cause was leaked, it was the Howard League that led the outcry from civil society, mobilising many human rights organisations who have expressed consistently grave concern at this development ever since. That's why I'm here this evening. So let me start by setting the background and why this is a matter of such concern to me from where I stand and in the light of my own personal and professional experiences. For many years, it's been a central part of this country's foreign policy to argue at every opportunity for the progressive abolition of the death penalty around the world. Earlier this year, whilst he was still Foreign Secretary, Boris Johnson was proudly tweeting graphics about the British government's record in leading the international abolitionist agenda. The progress over the years, globally, has been slow, but undeniable. Each year, the number of countries abolishing capital punishment or imposing a moratorium on executions has grown incrementally. Sometimes there are countries which resume executions and countries which drop the practice, but overall it's been a process of incremental progress towards abolition. The worst culprits are predictable. China. In China it's a state secret, so we don't know how many executions there are exactly, but it is generally thought to be at the top rank of the executing states. Iran, Pakistan and Saudi Arabia. And then of course the United States. But under the positive influence of the United Kingdom and its diplomats and other abolitionist states, the United Nations itself gradually shifted its stance. It wasn't until December of 2000 that the then Secretary General Kofi Annan, who died sadly last month, lent the support of his office to a worldwide moratorium after receiving more than 3 million signatures calling for an end to this barbaric practice. His successor, Ban Ki-moon, a few years later, famously declared, "The death penalty has no place in the 21st century." The position of the UN on the issue was becoming clearer and more resolute. But the leadership role claimed by the United Kingdom in that progressive campaign ground to a sudden shuddering halt this summer when it was revealed that the Home Secretary had allowed himself to be badgered, cajoled and seduced by Donald Trump's bellicose Attorney General Jeff Sessions into abandoning one of this country's core human rights commitments. I hope you will forgive me for saying that I consider myself reasonably well placed to make an observation on the implications of this. I spent 6 years, until very recently, as the United Nations Special Rapporteur on counterterrorism and human rights. In that role, I travelled around the world, meeting some of the most senior officials in the security field, wrangling with them often about the need to protect and promote human rights as part of an integrated and intelligent counterterrorism strategy. I discussed drones with John Brennan, the director of the Obama administration CIA, in his office at the Langley headquarters of the CIA in Virginia. I had a somewhat menacing dinner at a remote location with the head of the Saudi Arabian security services. I dealt with counter-terrorism officials in regimes with very poor human rights records, trying to find common ground with the leading national security advisors and judges in countries like Pakistan, Iran, Sri Lanka, and Israel. But when you're trying to persuade people from such regimes to observe human rights standards in their counter-terrorism strategies, the first thing you have to do is to learn to speak their language. You are, after all, touching on the very essence of statehood, the duty of government to protect the lives of its own citizens. And you know, the fact that I was British surprising as it may seem, always came up for discussion, always at the instance of my interlocutor, and normally within the first few moments of a conversation. Because despite this country's post-colonial legacy, or paradoxically maybe because of its post-colonial legacy, security officials around the world tend to trust the British to behave as they speak. I was taken seriously in that role and given a fair hearing in some surprising quarters precisely because of the United Kingdom's reputation for respecting the rule of law. But now, at a stroke, we are back to the days when the position of the British government could best be summed up in John Selden's 17th century adage, "Don't do as I do as I tell you." At a stroke, Mr. Javid has made us into a nation of human rights hypocrites who serve up pious admonitions which are in diametric opposition to our actions. There was no announcement of this dramatic reversal of policy on the death penalty. There was no debate in Parliament. There was no public explanation at all. Indeed, the Home Secretary did everything in his power to keep this awful act of collaboration with the swivel-eyed hawks of the Trump administration a secret. Just last week, the Security Minister, Ben Wallace, could be seen in Parliament trying to sell the absurdist proposition that the dirty deal struck between Mr. Javid and Mr. Sessions was somehow consistent with the United Kingdom's principled opposition to the death penalty. Surely he must know that no one is fooled. He and his boss are, to coin an old phrase, arguing the unarguable in defence of the indefensible. As George Orwell once said of the policy arguments of the sort that were being advanced by Mr. Wallace, indefensible policies can indeed be defended, but only by arguments that are too brutal for most people to face, and which do not square with the professed aims of their own political parties. Thus, political language has to consist largely of euphemism, question begging, and sheer cloudy vagueness. But vagueness will not do when a person's life is at stake, any more than it will do when a nation's reputation for human rights standard setting is at stake. Like it or not, many countries around the world still look to the United Kingdom to set an example. They rightly regard our judiciary as the best and most independent safeguard against maladministration that is to be found in any democracy anywhere in the world. They still harbour nostalgic notions about the effectiveness of our democratic institutions, and even, bizarrely enough, respect our increasingly ragged parliamentary process. But by adopting lofty and principled positions at the United Nations Human Rights Council, whilst at the same time striking a secretive deal to appease Donald Trump's lust for blood, Her Majesty's government has made a mockery of itself and of this country's international reputation for honesty and plain dealing. And Mr. Javid has revealed himself to be unprincipled and unfit to hold one of the great offices of state. He simply cannot be trusted to do the right thing. If in the fullness of time, when all is properly examined and the consequences of this debacle play out, if these events do not cost Mr. Javid his political career, then I despair of the checks and balances that are supposed to protect our Constitution. Last Wednesday, the 10th of October, the Howard League wrote to the Prime Minister about this case. The signatories to the letter included Kate Allen, the Director of Amnesty International UK, Andrea Coomber, the Director of Justice, Parvez Jabbar, the Director of the Death Penalty Project and a tireless advocate in capital cases from the Commonwealth, Caribbean and elsewhere. The signatories also included Lord Carlisle, one of the Howard League's greatest supporters and himself a former independent reviewer of terrorism legislation who knows a thing or two about some of the difficult decisions that need to be confronted. I also signed the letter, as did a number of the others who are here with us in the room this evening. But news of the letter's submission to Theresa May was overshadowed by the revelation that there had been other prior instances in which this current government has followed a similar course, again in secret, and again in the absence of any public or parliamentary debate. The fact that this has been done by these people before does nothing, of course, to diminish the objections. Indeed, the opposite is true. But since the letter received comparatively little public attention, I think it is worth reading to you the operative part of it in full. It's important because it reflects a consensus position among the leading human rights organisations in this country on the implications of this whole murky business so far as we can see them today. It said this: "Our government has a long-established position to oppose the death penalty in all circumstances. We should rightly be proud that our national strategy to promote abolition abroad was one of the first of its kind. A fundamental principle of this strategy is that this country must refrain from assisting in the use of the death penalty and from being complicit in executions. The position of this country in opposing capital punishment is clear, principled, and has been adopted by all political parties. This principle has manifested itself in policies not to extradite individuals without assurances that the death penalty will not be imposed, and it has led to successive governments imposing export controls on the materials used in executions. It is therefore astonishing that this government has reneged on this stance on this occasion." We note the statements made in the House of Commons by Ben Wallace MP on the 23rd of July that in deciding not to seek death penalty assurances from the US government, the United Kingdom consulted its own Overseas Security and Justice Assistance Guidance, the OSJA. The failure of the OSJA policy to prevent this kind of action suggests that the policy is inadequate, and again highlights the question recently raised by the Home Affairs Select Committee as to whether the Overseas Security and Justice Assistance Guidance is fit for purpose. Mr. Wallace's statement and the lack of action to seek assurances against the death penalty call into question the UK government's sincerity and integrity in upholding international human rights. It also strikes a blow in practical terms against efforts to eradicate the death penalty. As a matter of principle, say the writers, we must respect and uphold human rights. The prohibition on the death penalty is absolute, and there should be no circumstances in which the UK may be complicit in legitimising its application. This principle is universal, and we seek an assurance from you that it will be applied in all instances, irrespective of the nature of the request for British assistance and irrespective of the nationality, including in cases where a person is stateless." I hope you will agree with me that the issues raised by this case are at once moral and political, diplomatic and philosophical, as well as dry legal questions. But since I am a lawyer, and since we're concerned here with what purports to be the administration of criminal justice, let me give you 4 reasons why the government's conduct in this case must be condemned as being not just immoral, but also unlawful. The first reason is that the decision to provide mutual legal assistance without a death penalty assurance was a breach of this country's obligations under the European Convention on Human Rights. By the same token, and for the same reasons, it was also a breach of British domestic law. This government rightly shelved its plans to amend or repeal the Human Rights Act. They've also, in the Brexit negotiations, guaranteed to the EU that they will not be making any changes to the UK's obligations under the Convention. And you do not need me to stress that the Human Rights Act is a statute of the British Parliament, reflecting the consensus of the elected representatives of the British people. The Home Secretary's decision in this case is subject to a general provision of the Human Rights Act that makes it unlawful for a minister to take a decision that is incompatible with the Convention right. When he took this fateful decision, Sajid Javid was exercising the prerogative power of the Crown to afford mutual legal assistance to another state, another sovereign, in other words. But the days when prerogative powers were above the law and beyond the purview of the courts are long since past. These powers must be exercised lawfully and reasonably, and their exercise is subject to judicial review on public law grounds. So viewed in that way, the stark question raised by this case is whether it is lawful and reasonable for a government minister to authorise the provision of criminal evidence which could lead in a direct and causative way to the imposition of the death penalty in another jurisdiction, whether it is lawful and reasonable, in other words, for a minister of state to actively connive in a foreign execution. Like any black letter lawyer, I start the analysis by getting some clarity about the facts. Some of the facts are slightly surprising and not necessarily very well known. First of all, it's common ground in the litigation that is pending before the Lord Chief Justice that the United States prosecution of these two men will be reliant on the evidence provided by the United Kingdom. They need it in order to prosecute. Secondly, it is common ground that there is a serious risk that providing that evidence could directly and significantly contribute to the imposition of the death penalty. And it's common ground that the settled practice where another state asks for legal assistance from this country in a capital case, is that our government will condition that assistance with a requirement for an assurance that the death penalty will not be carried out. Why? What is the basis for that principle? The answer is obvious, because otherwise we would become complicit in a practice that we regard as inhuman and degrading, and therefore unlawful, whatever the circumstances, whatever the crime. The exercise of prerogative power by the Home Secretary is carried out, as we've heard, under an executive policy document called the Overseas Security and Justice Assistance Guidance. The policy makes it quite clear that the orthodox practice is to require an assurance before handing over any evidence. It states that a departure from that practice requires ministerial authorization. But that tells us only that there must be political responsibility and accountability if the prescribed practice is for any reason not followed. It does not even begin to authorize a practice that would otherwise be unlawful or contrary to our own constitutional values. And executive policy is not a source of law, it is a source of guidance by the executive to the executive of the exercise of legal powers that it already has. What makes the events in this case all the more remarkable is that when the UK was first approached for assistance by the US authorities, the government followed the guidance and requested a death penalty assurance as a condition of its cooperation. And the US government initially offered a partial assurance. Not a full assurance of the sort that we would require in every other case, but at least an undertaking not to make direct use of the evidence in a federal capital prosecution. It's true, the US government was bargaining. They were hoping to preserve the opportunity to make use of derivative, independent evidence discovered as a result of the assistance we provided them, but they were at least prepared not to deploy the evidence we gave them directly in order to secure a capital conviction. They offered this. As recently as last August 2017, the government was still insisting on a full death penalty assurance. That commitment seems to have eroded over time without any absolute clarity as to how, when, or why. By April of this year, however, Ben Wallace was still supporting the proposition that at least a partial assurance should be insisted on. But it was Sajid Javid himself who stepped in on the 22nd of June of this year and decided not to seek any death penalty assurance at all, not even the one that was on offer. He took that decision contrary to and in flagrant defiance of written advice from his own officials in the Home Office and from the Foreign Office, from the officials who would usually and in all but the most exceptional cases handle all requests for mutual legal assistance. And the Foreign Office advice in particular is important. The Foreign Office advice was clear and forthright, as one would expect, given the background I've described to you. The course proposed by this Home Secretary would, said the Foreign Office, undermine the United Kingdom's moral authority on the death penalty, whilst at the same time inhibiting its ability to seek and obtain death penalty assurances in future cases. Once you've made an exception, how can you insist that in all cases such an assurance is an inevitable concomitant of your opposition to the death penalty? The question that lingers, and I think will continue to linger for a while to come, is why did all this happen in that way? What was the true reason for this sudden volte-face in government policy? This unprecedented departure from long-settled practice, flying in the teeth of advice from officials, undermining this country's reputation for upholding human rights and for integrity in its international relations. This change of policy agreed in secret and kept secret from Parliament and the public. As I say, we still don't know why or how this happened, but we have every right to insist on knowing. We do know that Mr. Javid, because it's recorded, feared a hostile reaction from Jeff Sessions if he pressed for a death penalty assurance. And we do know that Mr. Sessions had publicly objected to the UK's stance in refusing to accept certain returning ISIS fighters for trial in this country, whilst at the same time purporting to impose restrictions on the way in which they would be dealt with if they were transferred to the US. I'll come back to that in a minute, because while I'm looking at the rest of the details, you might want to ask yourselves, looking at those two things side by side, the key questions here are not just why was there a complete abandonment of settled policy that had already been partially given effect in this case, why the sudden change of policy, but also, why not try these two individuals here in the first place? how do those two sets of decisions relate to each other? Which comes first? It becomes very important in judging the bona fides of what's taken place to know which decision is first in time. So why then, against that background, is what happened illegal? Well, first, the Home Secretary's decision was, as I have said, inconsistent with the Human Rights Act and with Article 3 of the European Convention prohibiting inhuman and degrading treatment. It's one of the anomalies of human rights law that it left a gap for the death penalty as being not a violation of the right to life. But as all of you will know, over many years, it has become recognised that the manner in which somebody loses their life is liable to or at risk of amounting to inhuman and degrading treatment, and now in later cases that the very fact of exposing somebody to the death penalty is inconsistent with that obligation. Since the Suring case in 1989, and this is perhaps the particular point of focus, since 1989, it's been settled law that handing a fugitive to another state where they will face the death row phenomenon which characterises the United States use of the death penalty is a violation of the protection against inhuman and degrading treatment. And that decision, which was momentous at the time, has been generally extended to all death penalty cases since then. The government was reminded of this in 2010 in the Al Sadoun case, where the European Court of Human Rights ruled decisively against the United Kingdom in connection with the decision of the British Army to hand two insurgents into the custody of the Iraqi authorities, knowing that they would face trial on capital charges, violation of Article 3. One must, of course, confront the fact that this case, our case, concerns mutual legal assistance rather than extradition. Does that make any difference to the principles in play here? Well, the government argues that it does, using what Lord Wilberforce famously called the austerity of tabulated legalism. Lawyers defending the Home Secretary's decision have argued in the High Court proceedings last week that the government only owes human rights obligations to people who are physically within its jurisdiction. Since, as it happens, the two accused are held by Kurdish forces in northern Syria, and since they are to be handed over to the United States for trial without ever falling physically into British hands, the government says they will remain at all times outside the espace juridique, as some like to call it, of the Convention on Human Rights. Based on this jurisdictional argument, the government asserts that it's free to do what it likes. Now, such technical arguments have never found favour in Strasbourg in death penalty cases. The Suring case is an example. Mr. Suring was not in danger of suffering inhuman and degrading treatment in the UK or in any other Council of Europe member state. He was in danger of being extradited to the US if the UK agreed to his extradition. Yet it was the decision taken here to extradite him that was successfully challenged in Strasbourg. The same, of course, is true in the Al Sadoun case and of all the other many decisions in this line of authority. The reason the sending state is held liable for what might happen in another non-convention state is because the sending state has put the individual in harm's way. It has taken action within its own jurisdiction, which will have the effect of exposing the person concerned to a serious risk of being executed. How, one may ask, is that materially different from what Sajid Javid deliberately did here? In all its fundamentals, the two situations are indistinguishable morally and legally. As one of our Northern Ireland Lords of Appeal, Lord Kerr, explained in the Ismail case in the Privy Council in 2016, the rationale for the principle laid down in Suring about extradition and applied ever since is that in that case the UK was proposing to take action that would, and these are his words, facilitate a violation of Article 3, not that it was proposing to inflict action in violation of that right directly. He characterised the principle in this way: it was because the actions of the UK authorities facilitated that outcome that a violation of Article 3 was held to be present in Suring. In effect, he said, the UK would have been directly instrumental in exposing Mr. Suring to the risk of being executed. And that's why it was unlawful. The same point was made by the South African Constitutional Court in the Mohammed case in 2001. Well, as I've already told you, it is common ground in the proceedings before the Lord Chief Justice that the actions of Mr. Javid are directly instrumental in exposing these two accused to the risk of being executed. No one disputes that. But even if one accepts for a moment Mr. Javid's tendentious analysis of the Convention's jurisdictional limitations, it still provides him with no answer and no defence. The rights guaranteed by the Convention and the Human Rights Act are there to supplement, not to displace, the body of rights guaranteed by the English common law. One of those common law rights is the right not to be subjected to cruel and unusual forms of punishment. A jurisdictional peculiarity or a jurisdictional limitation that is said to constrain the geographical application of a multilateral treaty cannot and does not in any way inhibit the application of the common law of England and Wales to the acts of a British Home Secretary in the exercise of the prerogative powers of the Crown. The authority of the law over the exercise of the Crown's prerogative dates back to and was the single greatest achievement of the English Civil War. We don't need the European Convention for that. In 2006, when the House of Lords ruled in the second Belmarsh case that evidence obtained by torture in Guantanamo Bay and Bagram Air Base was inadmissible in SIAC, an English tribunal, it did not rely on the European Convention for its conclusion, nor did their lordships rest their analysis on the express prohibition of evidence obtained by torture being admitted, set out in Article 15 of the United Nations Convention Against Torture. They didn't need to. Their decision rested squarely on the English common law and its historical abhorrence of torture as a method of proof. Like a sleeping giant, the common law doctrine of constitutional rights was memorably roused and called into battle by Lord Bingham in order to defeat attempts to legitimise the torturous interrogation methods used by the Bush-era CIA and their accomplices. As in the present case, the government put forward claims of exceptionalism in the Belmarsh case, based on the gross inhumanity of the 9/11 attacks and the terrorist threat undeniably posed by the claimants, who were described as extremely dangerous Islamist terrorists. But our common law rights were robust enough then to withstand such distractions from the principles that we stand for. And they should be robust enough here too. So let us be clear on one thing. The consistent policy and practice of the UK government, the decisions of the European Court of Human Rights, the rulings of other constitutional courts around the world, as well as the decisions of our own courts, have long since recognised that the death penalty as it is practiced in the United States amounts to cruel and unusual punishment. It's irrelevant that it's not regarded as such by the eccentric United States Supreme Court. What matters is our own legal standards. And it can properly be said that in this country, the prohibition of the death penalty itself and the prohibition of connivance in or facilitation of the death penalty abroad has hardened into a principle of our unwritten constitution. We have the benefit of a body of jurisprudence from the Privy Council on the imposition of the death penalty in the Commonwealth Caribbean. In many of those cases, Parvez Jabbar and the Death Penalty Project have been instrumental in setting some constitutional standards to place limits on the unconstrained use of the death penalty. But one of the most decisive moments in that campaign was the decision in 1993 of the Privy Council in Pratt and Morgan, in which it was accepted that long delays in the carrying out of a sentence of death in themselves are capable of amounting to inhuman and degrading treatment, in breach of the human rights protections that are afforded based on the European Convention analysis by the Westminster model constitutions that we bestowed on the post-colonial world. That principle is directly in issue here. The average period that an inmate spends on death row in the United States, suffering the agony of uncertainty about her or his fate, is 12 years. That is the very reason why the European Court of Human Rights found the proposed extradition of Mr. Söring to violate Article 3 of the Convention. So technical jurisdiction arguments about the Convention's geographical reach just won't wash. The words of the European Court of Human Rights in the Al Sadoun case, if you like, one of the strongest statements and most recent, were categorical and unequivocal. The court said, and I quote, "The use of the death penalty negates fundamental human rights." It negates them. The third reason why Mr. Javid's actions are to be regarded as unlawful is that they amount to the facilitation of an internationally wrongful act. The death penalty, certainly as practiced in the US, is inhuman and degrading. That much we know. As such, it is prohibited by Article 16 of the United Nations Torture Convention. For one state to aid or assist another state in committing an intentionally, internationally wrongful act is itself prohibited under customary international law. The International Law Commission's articles on state responsibility spell this out in Article 16. So very simply, it follows that complicity in such treatment is contrary to customary international law and subject to the familiar principles. Customary international law can properly be reflected in or inform developments in the common law. So all routes here point to the same conclusion. the problem with Sajid Javid's decision run into very deep waters, because he's touched on the very roots of British constitutional law. In a constitutional democracy such as ours, one with a cabinet system of government, it is not open to a minister to do away with the constitutional principle at his or her discretion by means of a secret decision reflected in a private letter to a foreign government without any particularised reasoning, particularly when it has not been the subject of consideration either in Parliament or in the courts. This leads me to the fourth and perhaps the most troubling aspect of this case, namely the haunting possibility that I touched on earlier, that this arrangement reflected a prior agreement between Sajid Javid and the Trump administration, by which British officials would actively pave the way for these men to be put in jeopardy of execution. On the face of it, the cumulative effect of the decisions taken by the Home Secretary and his officials in this case raised the prospect that there may have been some sort of gruesome deal reminiscent of the secret and private deal between Tony Blair and George Bush that was the focus of the Chilcot inquiry. If true, that would have very sinister implications and ought to have grave political ramifications for the government. Many observers are asking why on earth these two men are not being brought to London to be tried at the Old Bailey like so many others who travelled from the UK to fight for ISIS in Syria. Why should the government, which has a fixed policy of prosecuting these alleged foreign terrorist fighters in the UK courts, why should they have suddenly decided to step aside in this case and allow these two particular suspects to be handed to the Americans for trial? If they're prepared, as they are, to devote huge resources to trying every returning jihadist foot soldier in Crown courts in this country, as they do in scores of cases, why the sudden reluctance in this case, this grave case, which is so emblematic of the most brutal of the crimes allegedly committed by ISIS? Could it possibly be that a deliberate decision was taken here by the British government to collaborate with the Trump administration to execute the executioners? If so, that would be grossly unlawful, a bad faith exercise of public power, and contrary to the most basic tenets of democratic government. It might even arguably amount to misfeasance in public office, which is both a tort and a crime. The United Kingdom is the natural and obvious place for these two men to be put on trial. When the decision not to seek their return for trial here is set alongside the unprecedented decision not to seek a death penalty assurance, a disturbing picture starts to emerge. Taken together with the proposal that they should be handed to the US for trial on death penalty charges, the actions of the British government suggest at least the possibility of a dirty deal, a private pact deliberately made between the two administrations to ensure that the two accused men face the death penalty in the United States, precisely because Parliament has banned the death penalty in England. A dirty deal, in other words, to get around the clearly expressed will of Parliament. The crimes that these two men stand accused of are almost medieval in their savagery. But that is precisely why they deserve the highest standards of due process. There is no moral equivalence in executing the executioners. conniving in this revolting spectacle merely puts us on a par with those who are flouting and attacking our values. Britain has a proud commitment to constitutional democracy. The Home Secretary seems intent on sacrificing our principles on the pretext of defending them. Sajid Javid is dispensable, of course, and the Prime Minister should have immediately dispensed with him over this terrible fiasco. But she also needs to establish an inquiry into how this happened and who is implicated in this chain of unlawful decision-making. Let me leave you with just one thought. The Belmarsh case was for me a bit of a defining moment in my career. I had the privilege of appearing alongside the legendary Sidney Kentridge, drawing on his experience as a lawyer, defending the likes or representing the likes of the family of Steve Biko in apartheid South Africa. He vividly conveyed to a House of Lords sitting in Bank the simple moral iniquity of using evidence derived from torture. I remember on the other side of the court my exhausted and beleaguered opponent, a formidable government advocate, a lawyer who was both deeply moral and deeply professional to the last fibre of his body. But like any advocate, on a cab rank principle, he was bravely doing his best to defend the indefensible. It is my sincere hope that this time he, that advocate, will follow the morality of the situation and not be hoodwinked by technical arguments about jurisdiction and so forth. Because this time he's not the advocate arguing the government's position. This time round, 12 years since that Belmarsh case, Ian Burnett QC has become Lord Burnett, the Lord Chief Justice, the man now called upon to decide the future of Alexander Coty and El Shafi El Sheikh. In the absence of any shred of commitment to principle on this issue from within the present government, it is to the Lord Chief Justice that we must now turn for real moral leadership. Thank you.
I'm overwhelmed. It was absolutely amazing. Thank you so much, Ben. And he has promised me a draft of that, so we can put it on the website, a script of that, so we can put it on the website. I will allow a few questions before we break. Are there microphones? There are. We have one on each side. Could I get an indication of anyone who wants to ask questions? 1, 2... Right, I'll take those 2. Could you keep them short and say who you are? Sorry, was that? Yeah, 3. I'll take 3. Nice man there, and somebody at the back. Yes? And say who you are.
Good evening. My name is Joe from Prison Storm. On the subject of the United Kingdom's principled opposition to the death penalty, do you feel, sir, that on some level the United Kingdom government is inadvertently sending people to a death penalty in custodial sentencing?
Thank you. And over here, and there was one at the back over there as well. Thank you.
John York from Birmingham City University. On the point of judicial review, considering the jurisprudence of the cases on the death penalty, Zargowski, Mohammed and Sandiford, is this about degree of the extent to which this is unreasonable by the Secretary of State? And then on the point of your observation on the not complete assurance, it seems to me that's very consistent with Suring, which also was a not complete assurance before the European Court stepped in.
Interesting, thank you. And was there somebody at the back? Yes, nice lady at the back there, in the middle. I think it's behind you. The microphone's behind you. It's behind you. Thank you.
Hi, I'm Sophie from Norton Rose Fulbright. I was just wondering how far you think we should go to sort of not encourage death penalty elsewhere. So should we also be stepping away from trade relations with certain regimes or investment opportunities as well? So how far should we be going with this? Yep.
Interesting. Good luck with that.
So we have two political questions, I think, essentially, and one legal one. I could speak for hours with you privately about where you draw the line between certain forms of imprisonment and the obligation to ensure that punishments are proportionate and that they meet basic minimum standards. It's not this case, though. What is special about this is that this is a decision taken in secret in order to directly facilitate somebody's death. And whilst, as I say, I'm very happy to debate with you all of the issues for which, frankly, the Howard League has summarised in the very last line of that document, less crime, safer communities and fewer people in prison, is a principle which I think we can probably all agree with. The questions that you posed to me about Sandiford and the other cases, I think illustrate rather more the point that I was trying to make in the general thrust of this, which is that this is not a particularly complex moral problem. The answer to what should be happening here is obvious. The fact that it's possible to find certain decisions, which in the case of the ones that you're mentioning, are not on point, but are glancingly, possibly tangentially relevant, is a good example of why it's crucial that we have judges now dealing with this case who don't allow themselves to get distracted. All those distractions were available to the judges in the Belmarsh case if they had chosen to go down that path. But the Supreme Court was led by probably our greatest ever judge, and certainly in my living memory, Tom Bingham, a man of wisdom, principle and discipline. And frankly, you know, he was able to spot the difference between a morally questionable argument and an argument where the morality was very, very clear. And it would be a great shame for our system if the judges who have to deal with this case are unable to see with that degree of clarity what the right answer to this is, because the tools by which they can reach the right answer are lying right there in front of them. It's not a question of whether a previous decision of David Lloyd Jones when he was a first instance judge is binding or persuasive because he's a clever intellectual international lawyer, or whether a decision that was taken about not granting legal aid to somebody who happened to be arrested in Thailand, whether these things are comparable. It's obvious what the right answer to this situation is, and if the judges are not in a position to stand up and show it, then we're in trouble. And as far as the last question is concerned, I mean, again, that is fundamentally a political question. There's no... The issue of the leadership that the United Kingdom shows on the international stage in terms of its commitment to human rights principle and to human rights law is one which is, you know, I mean, the impact of this is particularly troubling, because whatever points you can make, and you can make many of them, about hypocrisy in certain aspects of UK foreign policy. You can talk about the UK criticising crimes against humanity in Syria and yet continuing to cooperate with the Saudi coalition in Yemen. I mean, I understand that there are many arguments to be had on that level. But one thing is clear, and I actually do believe this, the lawyers and diplomats who serve the Foreign Office in the international human rights and international non-human rights fora, the UN in New York and the UN in Geneva, they are principled people who believe in what they're doing. They're not people who are spouting convenient language because it's expedient to get a deal done, as so many lawyers and diplomats acting for other states are. They have a coherent political and legal philosophy and they believe in it. And what this type of active action does is it sends them into these discussions looking like fools, looking like all the others, being people that it's not really particularly worth listening to. And so if Sajid Javid had been Home Secretary throughout the period that we've been concerned with, there is no possible prospect that the United Kingdom would have led the charge towards abolition in the international community, but it's been able to do so because we haven't been landed with an unprincipled Home Secretary to this extent on this issue before. So that would be my response.
I think I'm going to end it there because I think that leaves us a lot to think about. We have been tweeting about this, I think, yes, nods from the back. So do follow the Howard League on Twitter. We will put Ben's speech up on our website, and if we've got your email and contact, we'll let you know. Clifford Chance very generously gives us a glass of something and some canapes afterwards, so there'll be an opportunity to carry on discussion for half an hour or so after this. I want to thank you for coming. I want to thank you for your support for the work of the Howard League, which you already give or are about to give. And most particularly, I want to thank Ben, because I thought that was absolutely fabulous, if very depressing. But, you know, we'll carry on fighting. Thank you very much, Ben. It's absolutely fabulous.